Hello, everybody.
Oh, shh.
If y'all have questions, I am glad to answer them.
Oh, I do have a question.
Sure.
So I was looking at the final exam, and I
Mhm.
don't know how well you'll be able to answer this because I know you can't like give me the answer, but there was a section of questions about evals with when it's a custody situation.
Mhm.
And I remember like reading the chapter about, what kind of tests you would do when someone is criminally not competent, like how to establish that. But I didn't see anything about like what to do with a parent custody situation. So is there like a specific chapter in the book? Like, is there somewhere where I overlooked that information?
So it would be maybe under civil assessment, but I definitely covered it in the lecture for that, and there should be a handout. So it would have been chapter 11's lecture. I talked about custody evals. So,
Okay. Okay, that's fine. I'll go back and look. I was like, it's possible I just like zoned out. I was like, I'm sure she talked about it.
I
So I
think
could
around
put
the time
something on there.
when you were having Wi-Fi problems too.
Oh, okay, yeah, something like that.
So,
Okay.
yeah, that's fine. Yeah, that's a really good question. So if there are any things like that where you can't figure out where to find them, this book is open, open book. So, please feel free to ask me. There's some stuff that I cover that the book doesn't. There's some stuff and Naila is offering to help too. So that's great. So certainly the PowerPoint and then my posted lectures for chapter 11 will cover that. But again, if you're going through and starting to work on that and you have questions, please, just shoot me an email, ask me before class like Hayden just did. I want you all to succeed. I would be happy to give everyone in this class an A. So all you got to do is turn in the work and make sure you're checking all the boxes on the rubric. So I am glad to help you do whatever you need to do to succeed. All right. So I actually thought, I'm glad Hayden you brought that up because I actually did think today that we would start with just looking again at the syllabus, making sure we're all on the same page for what's coming up at the end of the semester, because a week from today is our last day of class. 2 weeks from today are your presentations, believe it or not. So we are getting there pretty darn quickly. All right, and I'm gonna make sure the chat's up in case anyone wants to ask me questions that way. Alrighty, so interview paper, service learning paper, be thinking about those, be getting those in. I know it says the service learning paper is due today. That's a guideline, right? I know some of you are like just having to start your hours or things along those lines. So, if you need to pause on that and get that into me next week, that's fine. Again, I would really, really like everything by the 27th, if at all possible, just so that when you do your presentations on the 4th, I just enter in your presentation grade and you're done. Like you don't have to wait around to see what your grade will be. That day you'll have it posted on Blackboard. Probably the next day it'll go up on WebAdvisor. So especially for you, those of you who are seniors, this will be obviously pretty helpful in feeling very confident about graduating. So things to make sure you've turned in. I think there's a couple of people who still haven't turned in the midterm. Do that because that's 100 points. The interview paper, the service learning paper, and then the final as well. I have been sort of holding back on grading some things, hoping more people would turn it in. I realized for my abnormal class this morning, that's not really fair to the people who have turned it in. So this week, in between classes, I'm going to try to work on getting everything graded that's turned in. So like, for example, before I went and ate lunch after my abnormal class, I graded their papers. They turned in a couple weeks ago, but only half of them had turned in. So I was kind of waiting for everybody else to turn them in. So I will try to do that so you know where you're at. And so then remember that our exam period is not a exam. It's when you're going to give your presentations about your service learning experience. And I know some of you are using experiences that happened in the past, and that's fine. And some of you are doing stuff this semester, and that's fine. And again, remember, these are super informal, 5 minutes-ish, and it will just kind of probably just go down the list alphabetically and by first name, since that's how Zoom lists it, and go from there. On that day, you also have your hours log due. If you've got that done, you can turn it in now. You can turn in a spreadsheet, Word doc, or honestly, you can just like type it in where the assignment goes on Blackboard. It really doesn't have to be that fancy, just some sort of record of doing those 10 hours. So just a quick reminder on the papers that are coming due here. So if you haven't done your or your interview paper, you're gonna talk about your interviewee and their job, how it relates to psych and the law, and then relate it to 2 points covered in class. And the service learning paper is exactly the same format, basically. So you'll describe your site, how it was related to psychology and the law, and then you're going to relate your experiences to 2 points we've covered in class. The presentation is the same, basically. Just instead of getting some points for spelling and grammar, you get some points for talking well. And then again, your hours log are pretty low key as well. And I know for some of you who did these, last year, a couple years ago, you might not remember, exact date or whatever. So just give me a general description of what you did and how it accounted for 10 hours. The other thing we'll be doing, I'll probably give it to you all next Tuesday, is the self-eval for participation for the second half for, asking questions in class, particularly the group assignments. So please do fill this out, because this year, since I can't look around the room and see you working in groups, right? And I don't want to pop in and out of your Zoom rooms. I know some professors do that, but I feel like it really interrupts the flow. I ask that you fill that out just because it helps me to know, someone who might not ever talk in class, but is really vocal in the groups, right? So this is how all your grades will break down. And so you do have a good chunk of those still left. So if you're freaking out in any way, shape, or form about what's currently on Blackboard, remember you've got a lot of points coming. And if people follow directions on these things, they typically get good scores. Again, look at this rubric for each, right? And just make sure you're covering each of those and you'll get an A. Like, honestly, if you cover each of those things well, you'll get an A. Like, I'm not trying to make it tricky. That's one of the reasons why I do include such a detailed rubric right there. And if you go on Blackboard, there you'll even see the rubric is there. And I literally just open it next to your paper and check things off as I go through. So let me stop that share and ask if anybody has any questions.
What if I'm doing the papers and I just barely make it to 2 pages? Is that okay?
As long as you're covering anything, honestly, that's fine. If you cover all those points and you feel like you've done it well, I'm not really looking at how many pages it is.
Hi. You broke up a little bit on my end when you were talking about the group assessment thing. What's the actual form called?
So it's the self-assessment, and it's the same thing you did at midterm. You'll just,
okay, cool.
I'll update the form and probably give it to you all in an email next Tuesday. Because you're going to do one more group activity next Tuesday. So.
Okay, cool. All right, thank you.
Yeah, no problem.
Oh, actually, I do. Are we allowed to voice record our presentation in advance, or would you prefer it to be?
If that works for you, if you'd rather just play it, that's fine.
Thank you.
Yep. Yes. If you want to just videotape yourself doing it with your phone or with your laptop camera, or if you want to do like a voiceover PowerPoint, that's fine too. All right. I'm just double checking that no one signed on that I haven't accounted for being here. I think we're getting to the end of the semester, so a lot of people are trying to make the best use of their time and recognizing that I record these, thinking that this is not the best use of their time, which fair, whatever works for them. So I'm just double checking now. Alrighty, yeah, there are a couple people I missed here. Okay. Well, today we are starting a fairly elaborate mashing together of 3-ish chapters into one PowerPoint. So let me go ahead and share screen. So I'm going to present. And turn on the captions. Okay. So we're going to talk about traditional and non-traditional prosecutions. We're also going to sort of talk about what happens between when someone's arrested and when they go to trial. So again, kind of a mashup of a lot of different things. And then this lecture will continue on Thursday. We may start the stuff on corrections on Thursday. If we don't get to it next Tuesday, one day will be perfect for corrections. I do like a very brief lecture about that. And then we actually watch a documentary about the Stanford prison experiment. So that's how we will finish with that. And then doing our last group activity. So we are going to talk about traditional prosecutions first. So many criminal cases, honestly, are just dismissed. Maybe there's lack of evidence, or there are other difficulties that prosecutors perceive in the case where they just think it's not worth pursuing. For the vast majority of people charged with crimes and not fortunate enough to have those charges dropped, plea bargains, not trials, will resolve the case. Plea bargaining is a process in which a defendant agrees to say, I'm guilty for this, to plead guilty in exchange for some sort of concession from the prosecutor. So it might be a reduction in the type of charge, might be a reduction in the number of charges, or they'll say, you know, I'm not going to recommend the maximum sentence. Instead, I'm going to recommend, you know, probation, depending on what it is. I'm just going to grab the chat now so I can see if anyone has questions. By pleading guilty, however, defendants are giving up their right to a trial because they're saying, I'm guilty, right? Most civil cases, so lawsuits, for example, or perhaps a divorce, are resolved without a trial in a process called settlement negotiation. If we are talking about divorces, a lot of those are now decided in a process called mediation, where you'll have someone who serves almost in the role of a judge, but is not that official, but who will help people sort of figure out logistics of the divorce proceedings. And at any time, you know, during a settlement negotiation, during some sort of mediation for divorce, they can decide this isn't working and they can, you know, elect to go to trial. So what happens if you commit a crime and you're caught for it, right? And you're lucky enough that you're not shot at the scene. Anyway, if you are there is a law enforcement officer. They will probably arrest the suspect again, probably. And then they will be charged by the prosecuting attorney. So charging implies a formal decision to continue with the prosecution. and that decision is actually made by the prosecutor rather than the police. Then there's what's called the initial appearance. The Fourth Amendment to the Constitution requires that any person arrested be brought before a judge within 48 hours of their arrest. The judge then reviews the evidence summarized by the prosecutor and determines whether there is reason to believe the suspect committed the crimes charged. So they're not deciding they did it. They're just like, is there a possibility they did this, essentially? Hayden, I think it really depends on municipality so Hayden's asking about if you're required to do mediation beforehand. I think in some municipalities you are, others you're not. I know that a client of mine who was getting divorced in South Carolina when I was in Augusta, Georgia, they're right across the river from each other. So I would see some clients from South Carolina. They opted to do a mediation. So apparently they had the option, but yeah, it sounds like in some jurisdictions you have to. Yeah.
I think that that's just like a strategy to try and get people to like resolve things before you go to court, and that like takes up time in the civil docket. Because I know that for real estate stuff, because my grandpa's trying to buy a condo right now and something went FUBAR with the contract, but I know that you have to legally, like the court won't hear it unless you've like documented and tried to do mediation to resolve the issue, and then you can like go to court.
That makes a ton of sense because courts are so busy, like you said. So yeah, that really makes a lot of sense where they would be like, try this first, please, like stay off of our docket if we can, right? Yeah, that's a really good point. Yeah, so, and again, this is the frustrating thing about the American system, right? Is that because we have so many layers of government, right? Federal court might be different from the state court, might be different from the county court, right? Within the same area, right? So like, give you an example, going back to jury selection, there was a year that my mother got called, I think it was the county court, was downtown in Detroit. So she got called down there for jury duty. And then there was like a more local court. I don't remember exactly what the municipality was, how it worked, but like a month later, she got called for jury duty for that. And she called them and was like, I already did this. And they're like, no, that was a different court system, right? And like some of their procedures might be different. And again, they were maybe a 30-minute drive apart. All right, so yeah, this can get complicated, frustrating, confusing. Actually, one of my friends is an attorney. She does bankruptcy law, and she actually found the Virginia bar pretty challenging because you also kind of have to know DC and Maryland law in case you end up operating up in the, whatever they call it, DMV, I think, area up there. So yeah, it's fun for attorneys, and then obviously overwhelming for someone who doesn't know what they're doing in the legal system. So yeah, so you get to appear before a judge. The judge will review the evidence and then inform defendants of the charges against them, inform them of their constitutional rights, review the issue of bail, and appoint attorneys for those who can't afford to hire their own. So the judge decides whether or not to set bail. If there is bail, you can pay it and get out until your official trial. If you can't afford bail, even if it's set, you're staying there, right? And, you know, some people can't afford an attorney on their own, so that's when a public defender would be appointed. I'm trying to remember, I think it is John Oliver did a really excellent segment a few years ago about public defenders, and it's horrifying, like what their caseloads are like and how little time they have to dedicate to each case. So it's unfortunately not a great option, but the only option a lot of people have. All right, so what happens after that? There's a preliminary hearing where the prosecution must offer some evidence on every element of the crime charge. The judge must decide whether the evidence is sufficient to pursue the case further. So again, the judge is not deciding whether or not the person did it, just whether or not there's enough evidence to move forward. No jury is present here, and defendants rarely testify or even offer any evidence of their own. And the judge will sometimes send the case to a grand jury, which we'll talk about on the next, actually it's on this slide, but my next section of notes on my notes here. Or the judge might reduce the charges, either because the judge believes the evidence doesn't support the level of crime charged by the prosecutor, or here's where that plea bargain will start to come into play. So the grand jury consists of citizens drawn from the community. They meet in private with the prosecutor to investigate criminal activity and return indictments. So indictments are complaints prepared by the prosecutor describing the crime charged. The grand jury may call witnesses if it is dissatisfied with the witnesses presented by the prosecutor. In some states, but not all, the defendant has the right to testify. Again, it's going to really depend on your municipality. In about a third of the states, a criminal defendant cannot be prosecuted unless a grand jury has found grounds to do so. So in about a third of the states, it's required that you put it through a grand jury. The remaining states permit the prosecutor to proceed either by grand jury indictment or by preliminary hearing. If the grand jury does decide there is sufficient evidence to justify the defendant being tried, it will issue an indictment. Then there will be the arraignment. So at the arraignment, the judge is going to make sure that defendant has their attorney set to go, either someone they've hired or a public defender. The defendant is asked to plead guilty or not guilty. It's pretty customary for defendants to plead not guilty at this time in order to provide opportunities for both discovery, where the defendant's attorney can review some of the evidence against the defendant, and for plea bargaining, right? So if you say you're guilty here, you're kind of closing the door on yourself. But if you say you're not guilty, then you're, leaving it open for all these options. All righty, so defendants and their attorneys want to be aware of the evidence and that the prosecution will use to argue its case. So in civil cases, each side is entitled to discovery, where each side can question the other side's witnesses and review documents that the other might use at trial. So anything that you're going to present at the trial, the other side will or should have the opportunity to review, and that's discovery. So whether that's a witness or whether that is, a stack of documents, right? In criminal cases, what the prosecution must reveal to the defense varies, again, by municipality. Most states require that only that the prosecutor share evidence that is exculpatory. That means it tends to show the defendant is not guilty or suggests that the prosecution witnesses are not credible. So that would mean they wouldn't have to share evidence that they're going to use actually against that person in court. In many states, the defense is required to notify the prosecution if it intends to rely on something like an insanity defense, so going for not guilty by reason of insanity, or if they're going to try to use an alibi as a defense. Like, we have witnesses who say this person was here at the time the crime was committed, so they couldn't have done it. During the discovery phase of the case, both sides file pre-trial motions seeking favorable rulings on the admissibility of evidence. So for example, they could motion for separate trials if multiple charges are being brought. So they could say, no, we want a different trial for each of these charges. They can have a motion to sever counts. We have a motion for change of venue. So this would be you're in a county where like everyone knows the defendant, right? This person was the mayor, say, or the sheriff or whatever. You can argue, look, we need to have this trial somewhere else because there's no way this person's going to get a fair shake because everyone knows them. You can make a motion to suppress a confession or other statement by the defendant. Often you would be arguing they made that under duress, for example. And then you can also make motions in limine, which are a request for a pretrial rule. So judges must decide whether to keep criminal defendants in custody between arrest and trial, or whether to release them with a promise to reappear for later hearings. Judges can deny bail if you think this person is a flight risk or this person is just too dangerous, right? We don't want to let them out because of that. Judges can require that money be deposited with the court. So again, either you pay the full amount or you would use what's called a bail bondsman. And so with a bail bondsman, you would pay like a percentage of it, and then the bail bondsman would pay the rest for you. That does mean, however, that like if you skip bond, if you don't show up for your hearing, the bail bondsman has the full right to track you down, right? Because they want to get their money back. Just have to say, like, from what I've observed, it seems like bail bondsmen make bank. There is a bail bondsman who lives in my neighborhood. I know because every single one of his vehicles is wrapped with his logo. And he lives in one of the larger houses at the back of my neighborhood, and his cars are usually, like, I think at one point he had a Hummer. At one point he had a Range Rover. Like, those aren't cheap, right? So, you know, if you're interested, this might be a direction to go if you kind of have the start off. Hayden agrees, they make bank. I also feel like he gets a new car like every couple of years. I'm like, oh, new wrap, okay. Let's see, what else? They can also require that a third person be responsible for the defendant's future appearances. And then they would forfeit the money if the defendant doesn't appear. So this might be where like someone puts up the, yeah, I don't live in the larger houses. I live in the ones right up front. The back of my neighborhood has some like 3-story houses on a lake. We're pretty happy with our little like happy 2-story. So yeah, our neighborhood is a whole thing because there's also apartments and condos here. Like you could do a really interesting sociological study about the people who live in our neighborhood on a golf course. Because there's a whole range. There's probably millionaires in the back, and clearly we're not that, right? And clearly the people who live in the apartments are not that. So, yeah. We really should. It's been hard, obviously, during COVID, but we've been here a few years. We should have been making our way in, making friends with people on the lake. But I feel like we actually have gotten to know our neighbors better because we're all always outside because we don't want to be cooped up. Haven't met the bail bonds guy, but have like waved at him. I also, Dr. Wansing, who teaches religious studies, lives in my neighborhood. So he's forever waving when we go by or stopping to chat with me across the driveway, which is nice. So, okay, sorry, tangents. That's all right. It's that time of year. Yeah, if the third person is responsible, sometimes you have like the person's parents like putting their house up as collateral. Like this could get really scary, right? So you want to make sure that that person doesn't skip bail because then their parents could lose their house. In addition to ensuring the defendant's return to court, bail has a secondary purpose, which is protecting public safety. So bail decisions are influenced by both legal and extra-legal factors. So legal factors include like the seriousness of the offense. So let's say they murdered somebody, right? That's really different than if they, maybe keyed someone's car, right? And got caught for vandalism or destruction of property. Versus extra legal factors will also play in, unfortunately, and probably not surprisingly to anyone on this Zoom call. So extra legal factors are not something that anyone is consciously thinking about, but things like gender, race, ethnicity, age of the defendant can make a difference in the decisions here. So in terms of the legal factors, research has shown that bail is likely to be denied or set very high, so like prohibitively high where the person can't afford to bail out, when the offense was serious, and especially when the defendant has prior convictions, because they've shown if you let them out on bail, they'll probably reoffend. Extra legal factors, so again, race and gender have been shown to have significant impacts on judges' pretrial decisions. For example, Black defendants were less likely than others to be released on bond, and female defendants were actually assigned lower bail amounts than males for the same crime. So that's not how it's supposed to work, but because these are decisions being made by humans, that happens, right? We have biases that come into play. Judges tend to use a mental shortcut in making these decisions called the matching heuristic when determining whether this bail should be allowed. So they search through a subset of available case information and then make a decision on the basis of only a small number of factors like offense severity and prior record, often ignoring other seemingly relevant information. Like my favorite recently, right? Again, things that would never happen to like a Black male that this happened to. Like one of the women who stormed the Capitol in January wanted to be released on bail so she could go on her vacation to Mexico. And the judge was like, okay. It's like the whole, like you're not supposed to leave town, much less the country, right? I just don't understand. Other than racism, bias, white people getting away with shit, to be perfectly honest. Fully acknowledging my own privilege here. That could probably happen to me were I in that scenario. So does pretrial release affect the trial outcome? Yes, defendants who are detained in jail are more likely to plead guilty or be convicted, and they receive longer sentences than those who can afford bail, even when the seriousness of their offenses and the evidence against them are comparable. The other question here is, can we accurately predict who's a high-risk defendant? So around 1970, a push began for legislation that would increase the use of what's called preventative detention, the detention of accused persons who pose a risk of flight or dangerousness. This assumes that a valid assessment of risk and accurate predictions of future dangerous conduct can be made, an assumption that's not always correct. And again, we're not like calling in a well-trained psychologist. This is often just sort of like the judge's gut or based on similar cases. All right, so the next thing that we're going to talk about, and for whatever reason, I didn't reorganize my notes. I just gave myself some notes on where to go. So let me just find it. We're going to talk about pretrial publicity. I love when I make myself make things so easy for myself here. Here we go. Okay. So there are conflicting rights when we're thinking about trials in general, much less pretrial publicity, right? So the First Amendment allows the press to inform the public about criminal investigations, right? We have the freedom of speech, we have the freedom of the press. The Sixth Amendment concerns the right to a speedy public trial before an impartial jury. Impartial is the key word here, right? So the First and Sixth Amendments clash here when the press publishes information that threatens a defendant's right to a trial by impartial jurors. A common problem occurs when local media and internet sources disseminate prejudicial information like the defendant's criminal history before the trial. So then it becomes exceedingly difficult to find jurors who have not already heard this, because it's exceedingly difficult to disregard previously acquired information. There are, as you can see, a whole history of court cases related to this. So in Rideau v. Louisiana in 1963, the court decided that exposure to news with information strongly pointing to the defendant's guilt is actually a violation of due process. We are denying that person due process if the jurors have exposure to media information saying this person's guilty. Nebraska Press Association v. Stewart in 1976, the court ruled that a trial judge could not order the press to refrain from publishing information likely to be prejudicial for a defendant, unless the defendant would otherwise be denied a fair trial. So this basically said, look, the First Amendment usually rules, but if that's going to get away with the Sixth Amendment, then the judge can issue a gag order where the press is not allowed to talk about certain things. In Richmond Newspapers, Inc. v. Virginia, close to home, in 1980, it said the press cannot be barred from attending and reporting a trial because the First Amendment guarantees public access to criminal trials in particular. Now, the really interesting thing is that it really depends on the municipality what access means, right? So you look at local courts and often they will allow like local news cameras in there, right? The Supreme Court does not allow any cameras. They do allow reporters to sit in, but they can only take notes, and there are like court sketch artists, that type of thing, but they don't have any camera recordings of it. You know, it's sort of an antiquated rule at this point, but you can also argue that it creates a different experience in the Supreme Court than if it were a media circus, right? You can see it both ways. I'm hitting on all the good John Oliver stuff. Another good thing John Oliver did a few years back is he filmed footage of dogs in little Supreme Court robes and like asked media outlets, like, please use this when you talk about court cases to try to like get people's attention, because it can be really hard to talk about something you don't have video footage of. I don't know if any local news ever did that, but I just thought that was super creative. Like RBG was a little teddy chihuahua because she was tiny. It was pretty creative. All right, and then there is Ganetco versus De Pasquale in 1979. Said the press can be excluded from pre-trial hearings in which potentially prejudicial material can be an issue. So if the press is gonna find out stuff at a pre-trial hearing that could then bias the jury and deny Sixth Amendment rights, they can be barred from the pre-trial hearing, but not the actual hearing. And then Moomin v. Virginia in 1991, the court held that defendants do not have a constitutional right to ask prospective jurors about the specifics of their exposure to pretrial publicity. So as you can see, these are all kind of conflictual, right? There's not one clear message. And so judges in each case have to kind of weigh the individual information about the case in order to make decisions to not violate the First Amendment or the Sixth Amendment. So what are the effects of pretrial publicity? Well, this is the type of stuff psychologists love to do studies on. It's, you know, social psych at its best, right? Thinking about how media influences people. So we have a lot of research in this area. So there's two types of studies, experimental and field studies. In experimental studies, participants are first exposed or not exposed in the case of a control group. So they would randomly assign people to be in an experimental group or a control group to some form of publicity, and then they're asked to assume the role of a juror in a simulated trial. And then researchers measured the impact of the publicity on the jurors' decision-making. Pretrial publicity has been found to affect jurors' evaluation of the defendant's character, the extent to which they like or sympathize with the defendant, their pretrial thoughts about their guilt, and their final verdicts. But why? Pretrial publicity may bias jurors' interpretations of the evidence presented at trial. Also, jurors can believe wrongly that the pretrial information was actually presented as evidence at trial, which is sometimes called a source monitoring error. Like, you know you heard something, but you don't know what it was. You don't know when you heard it or where you heard it, right? It's just sort of like, I remember hearing about that. Where did I, like, my husband and I will do this sometimes, like, did you tell me about that? Or did I tell you about that? Right? So, you know, it's hard to remember exactly where you got information sometimes. Presentation of publicity via television has been found to have a greater biasing impact than the same information presented in print, but the combined effects of TV and newspaper publicity had the greatest impact at all. So if you're getting the same information from different sources, your mind sort of goes, well, if it's from more than one source, it must be true, right? Participants are generally unaware that their opinions have been biased by this material. This does not surprise me. Humans are generally unaware when we're biased in general. And specific pretrial publicity, case-specific information made available prior to the trial can affect the sentiments of the jurors in the trial. When psychologists do these studies and use mock juries, members of those mock juries can also be influenced by generic prejudice arising from media coverage of issues not specifically related to a particular case, but thematically related to the issues at hand. So how the media covers domestic terrorism in general, right? If the media is always talking about, oh, this poor white man with a gun who had mental health issues, versus this is a domestic terrorist who went and killed 20 people, right? It makes a difference. Also, obviously, racial and ethnic stereotypes, and even news information about things like tort reform can influence things. In field studies, respondents are surveyed to assess the effects of publicity on a particular real-life case. So in experimental studies, you're going to be more abstract, like what would happen in a theoretical case. Field studies, you're actually going to look at, okay, there's this high-profile case going on right now. How is publicity affecting it? By polling people exposed to reports of actual crimes, researchers have found that people who are exposed to this pretrial publicity possess more knowledge about the events in question, not surprisingly, right? Are more likely to have prejudged the case. Again, I think this is just a human tendency, right? And are more knowledgeable about incriminating facts that would be inadmissible at the trial. So they've already got information that wouldn't be allowed at the trial in their heads. So again, they're not going to remember, did I find it out before or did I find out during the trial? And that's going to influence things. Both types of studies, not surprisingly, reveal that jurors may be adversely affected by pretrial publicity. So what are the remedies? Well, there can be what's called a continuance, where you postpone the trial because the media has been covering it so much right then. The most popular method is just to expand your voir dire. So if you remember voir dire, that's where you are making jury selection and you can like rule people out, and the judge might give more options to rule out, or maybe you just go through a larger portion of people to try to find the people who haven't been exposed to as much pretrial publicity. Judicial instructions could help as well. If the judge says, you know, you shouldn't pay attention to anything you heard in the news media. Unfortunately, these first three things we just talked about, they are largely ineffective according to the research. Really the only thing that works is that change of venue that we already talked about. Based on research, social sciences in general will argue in favor of a change of venue because it's the best way to protect the Sixth Amendment when there has been a lot of pretrial publicity in a certain area. All right, so now we're going to talk about plea bargaining in criminal cases. So most, as you can see, the vast majority of criminal cases, 90 to 95%, end prior to trial with a plea bargain. The defendant pleads guilty to some charge, often a lesser charge than they were initially charged with, in exchange for concession from the prosecutor, like a reduction in the charge or a reduction in sentencing, that type of thing. In charge bargaining, the prosecutor drops some charges in return for a guilty plea. And because this is something that happens quite a bit, the prosecutor often will overcharge the person. So charge them with more things than they actually want to, or charge them with a higher crime than they actually hope to get as the last official charge. So essentially, prosecutors go in assuming there might be a plea bargain. Plea bargaining may also take the form of sentence bargaining, in which prosecutors recommend reduced sentences in return for guilty pleas. Now, prosecutors don't actually decide this, but in general, judges will follow the sentences recommended by a prosecutor. So why do defendants plead guilty? Why on earth would you get up and be like, yep, I did this? Well, one, because if they are very likely to be convicted, right, that it's probably to their advantage to reach a plea deal. And the second is that because if they're convicted, they would face really lengthy sentences. So maybe they are going to prison for life. Maybe they're going to death row, right? So they might create a plea bargain in those cases. Why do prosecutors plea bargain? Why bother? Why not just try to get the highest thing on them? The first is to dispose of cases in which the evidence against the defendant is weak or the defense attorney is a very formidable foe. So essentially what they're trying to do is ensure a win, because that helps you maintain your job if you keep winning cases, right? They also might do it to obtain the testimony of one defendant against a more culpable defendant. So if you rat out your compatriot, we'll drop the charges against you or make them lower. And sometimes it's just to expedite the flow of cases, right? Think about how busy the court system is right now. And now imagine if 95% more cases had to go through it, right? So there's a big piece of this that like, okay, we can get this one done, we can get it off our plate, we can move on to the next thing. So what are some psychological influences in the plea bargaining process? So one is framing effects. So the way decision alternatives are framed as either gains or losses can have an impact on a person's choice. Individuals are more willing to take chances when the decision alternatives are presented in terms of gains than in terms of losses. We like carrots, not sticks. There's also something called the overconfidence bias, where people do tend to be too optimistic about their chances of securing favorable outcomes. And sometimes that can lead you not to take a plea bargain, but sometimes that also means that the prosecutor has to kind of like bring you down to earth, if that makes sense. So advocates of plea bargaining cite the following justifications. They relieve that backlog of cases. Plea bargains facilitate the prosecution of other offenders because of that, maybe more severe, serious offenders. And the absence of a trial reduces the involvement of various criminal justice personnel, again, relieving some of that strain. Critics cite the following justification for plea bargaining. Improper sentences. They say sometimes they're too harsh, but more often they're too lenient. And those are likely during plea bargains. They also argue that the process encouraged defendants to surrender their constitutional rights. If you say, I'm guilty, you surrender a lot of rights. Critics also say that this gives prosecutors too much power. Essentially, the prosecutor is sort of acting as a judge in these scenarios. And they also argue that innocent defendants may be coerced to plead guilty, right? And certainly there are any number of true crime podcasts, right, that kind of seem to hint towards this. I'm thinking of Serial, but there are plenty other out there, right? All right, so what about in civil cases? Let's talk about settlements. So the vast majority of civil disputes are also resolved without a trial. Again, this helps the court system. This helps alleviate, time spent, money spent, etc. And so this process is called a settlement negotiation. And this is typically in private negotiations between the attorneys representing the disputing parties. The legal merits of the case are what is going to matter most in these scenarios. And outcomes are also influenced by the negotiator's reservation price. So the defendant's reservation price is the maximum amount of money that he or she would be willing to pay in order to reach an agreement. The plaintiff's reservation price is the minimum amount of money that they would accept in order to settle the claim. Right, so the plaintiff wants to get as much money as possible. The defendant wants to pay as little as possible. So they kind of have to find something in the middle then. In considering the merits of the case, plaintiffs, defendants, and attorneys are often influenced by heuristics or psychological biases. The self-serving bias occurs when people interpret information or make decisions in ways that are consistent with their own interests. This is something most humans do all the time, right? We're thinking about ourselves, rather than in some sort of objective fashion. So parties have difficulty seeing the merits of the other side. Again, nothing shocking about this. But what becomes really an issue here are the anchoring and adjustment bias. So this occurs when negotiators are strongly influenced or anchored by an initial starting value and don't sufficiently adjust their judgments away from this starting point. The higher the first offer, the higher the ultimate settlement. And so this is why you'll hear in civil cases people asking for $100 million, right? Because they kind of know they're not going to get that, but by anchoring it that high, it means that their eventual payout will be higher than if they started with something lower. So what is the purpose of a trial? So Miller and Foster in 1977 identified 3 images of the trial. You can look at the trial as a search for the truth. This assumes that the truth can be ascertained and that it will emerge from confrontation of conflicting facts. It also assumes that judges or juries can put aside their prejudices and decide the case with a dispassionate analysis of arguments and the evidence. Not surprisingly, it can be very difficult to meet this ideal, but this is the ideal. This is why we do a trial system in the way we do it in the US. Is that the ideal is this is what would happen. Through the process of the trial, the truth will be revealed. You can also look at the trial as a test of credibility. This acknowledges that facts and evidence are often incomplete and biased, and the judge or jury must weigh and evaluate the truthfulness of these 2 opposing sources, or sometimes more than 2 opposing sources, right? Unfortunately, both judges and jurors can make unwanted and unwarranted inferences, as we've talked about already. And then you can also see the trial as a conflict resolving ritual. The trial provides a mechanism to resolve controversies to create the sense that justice is being done. And I think there are probably elements of all 3 in what actually happens, right? But there are certainly players in the system, and probably more often members of the general public, who see trials as more or less of one of these. So what are the steps in the trial process? First, there are preliminary actions. And we've kind of hinted at some of these and learned more about others of these throughout the semester. So discovery is that pretrial process by which each side tries to gain vital information. So like police records, for example, about the case that will be presented by the other side. Basically, you want to know the other side's playbook so you can get ready to defend against it. You're going to draw that panel of prospective jurors called a veneer from a large list, again, often based on voter registration lists and lists of licensed drivers. Once that veneer has been selected, you're going to go through voir dire in order to question and select the eventual jurors. Then, during the trial, it starts with opening statements. Lawyers for each side are permitted to make opening statements. These are not part of the evidence, just overviews of the evidence we presented, but the judge is listening, the jury is listening, right? So they will be influenced by this. The prosecution or plaintiff usually goes first. The defense's opening follows immediately after, or the defense can choose to wait until it is their turn to present evidence. And there are different strategic ways why you might choose one or the other. And again, this is why really good lawyers get paid really big bucks, right? Because with something like an opening statement, you set the scene. If you are compelling in your arguments and you can get that jury on your side, they are going to see everything throughout the trial through your lens. After opening statements, the prosecution or plaintiff calls its witnesses. Each witness will testify under oath with the threat of a charge of perjury if the witness fails to be truthful. And perjury in and of itself, can be something that you can get in quite a bit of trouble for. After the prosecution or plaintiff's attorneys have presented all their witnesses, it is the defense's turn. Each witness undergoes direct examination, cross-examination, redirect, and recross. So direct examination would be by the attorney who's bringing you as a witness. Cross would be the opposing attorney. And then your attorney gets to step back in. Recross, the other attorney gets to step back in. After both sides have presented their witnesses, one or both may decide to ask the judge for permission to present rebuttal evidence, which attempts to counteract or disprove evidence given by an earlier witness. So here is where, let's say someone brings an expert witness. Say it's a psychologist saying this person should be considered not guilty by reason of insanity. The other side might now pull in an expert witness who says the opposite, right? Again, as we talked about before, psychologists are supposed to be unbiased. They can just interpret things differently, or some not so ethical psychologists can take a lot of money to say what people want them to say. Just like any other field, we do have unethical people, unfortunately. Once all the evidence has been presented, each side is permitted to make a closing argument or a summation. Typically, the prosecution or plaintiff gets the first summation, followed by the defense, after which the prosecution or plaintiff responds. Then the final step after that is for the judge to give instruction to the jury, obviously in a jury trial. If there's no jury present, the judge wouldn't have to give them instructions. The judge knows the instructions and doesn't have to say them out loud to themselves. So the judge will, in some states, the instructions will actually precede the closing arguments. So you can do it either before the closing arguments, after the closing arguments. The judge will inform the jury of the relevant law. The judge will instruct jurors about the standard they should use to weigh the evidence. So with criminal charges, it's usually that jurors must be convinced beyond a reasonable doubt that the defendant is guilty before they vote to convict. And so we saw this in 12 Angry Men, right? They talked about, like, now I have a reasonable doubt, right? The idea is if there's any reasonable doubt, you shouldn't convict the person because that's unjust. In a civil trial, the preponderance of evidence is necessary for finding favor on one side. Preponderance of evidence is essentially 50% plus a little bit. The way that it was described to me by a former Title IX agent on campus was 50% plus a feather. When the jury has reached its verdict, its foreperson informs the bailiff, who informs the judge, who reconvenes the attorneys and defendants, or in a civil trial, the plaintiffs, for an announcement of the verdict. So, what are the advantages of a trial to each side? Like, why do we go through this really long process? Right? Why don't we just like hand the judge some papers and be like, decide this while we all go to lunch? Well, the prosecution is the first to address the judge or jury, so they get what's called the primacy effect, where they are the first thing in your mind. It has the full resources of the government. The prosecution presents its evidence before the defense. And at the end of the trial, the prosecution gets to go first and also gets the chance to offer a final rebuttal to the defense's closing argument. So what are the advantages to the defense? Well, they don't bear the burden of proof, right? In our country, you're supposed to be innocent until proven guilty. We know that that doesn't always happen, certainly not when race or other factors are involved, right? But that's what's supposed to happen. So it's not up to the defense to prove they're innocent. It's up to the prosecution to prove that person's guilty. Remember, they have to prove it beyond a reasonable doubt. If there's any doubt in the jury's mind, they can acquit. Sorry, I think of the O.J. Simpson trial, which I believe I've told you before happened when I was in like middle school or high school, I think. And I just remember one of O.J.'s attorneys having him try on the gloves, which were like dried with blood, so probably didn't fit the way they normally would. And his attorney saying, if the glove doesn't fit, you must acquit. So again, being a very energetic, charismatic person, thinking of things that'll stick in the jury's mind, right, can be really helpful. The prosecution must turn over all that exculpatory evidence during discovery. The defense may also have more opportunities than the prosecution to remove potential jurors without giving a reason during that voir dire process. Defendants do not have to take the stand as witnesses on their own behalf. There's no law saying that they have to. Johnny Cochran, yes, thank you, Naila. I couldn't think of his name. I can't remember any of the attorneys' names. All I remember is that the Kardashians' dad was involved somehow, but I only know that because of the show. But yes, Johnny Cochran, very persuasive attorney. It's why OJ was found not guilty, right? Defendants do not have to take the stand. Oh, I've said witnesses on their own behalf. In fact, a lot of times they won't because they don't want to incriminate themselves by accidentally slipping up. Defendants who are found not guilty can never be tried again for the same crime. That's actually called double jeopardy. So you might appeal the case on a technicality, but you can't go back and like do a whole new case on the same crime. There's actually, I think, a 90s movie with Ashley Judd called Double Jeopardy that plays with this idea, where she's sent to prison for killing her husband. It turns out he never died. So she's like, double jeopardy, and she just kills him because she figures she won't get into trouble. You know, I don't know how that would actually go in real life. It's probably not that common of an occurrence. All right, so sentencing. If the defendant in a criminal trial is judged guilty, then we have to punish them in some way. That's how our system works. In most jurisdictions, a trial judge will decide the punishment, will do the sentencing. In a 2004 decision, Blakely v. Washington, the U.S. Supreme Court ruled that judges may not increase defendant sentences on the basis of what they perceive as aggregating factors. So circumstances that seem to make the crime worse. So in this Blakely v. Washington case, the court reserved those determinations for juries. So if you want to increase the sentence, the jury has to be the one who decides the sentence. Now, this is obviously different if there are multiple crimes being tried at the same time. It's like one case that comes to mind for me is the Larry Nassar case. So if you're not familiar with this case, this is a horrific case of a team doctor for USA Gymnastics who abused women, girls, and it sounds like some men and boys as well. At least 300 of them over his years there. And he would do these medical procedures without a glove, or he would penetrate them vaginally. Absurd. And everyone covered for him because that's what shitty people do, right? Well, he, again, had these multiple cases. And so technically, you can be charged the full amount for each case. And so the judge actually sentenced him to something like 300 years in jail, in prison because of this. Because basically she just said, like, you're never getting out. You're never going to see the light of day. This is awful what you did. And yeah. So certainly that can be done without going through a jury in those cases. In a handful of states, all sentencing is determined by a jury. In cases involving the death penalty, jurors rather than judges decide the sentence, and that's from Ring v. Arizona in 2002. And again, we saw a piece of that in 12 Angry Men, right? They kept kind of referencing, like, if we find him guilty, he's going to the chair. Do you want to just send this kid to the chair without being totally sure, right? So the idea is it's not just one person making the decision to kill somebody else, basically. Okay, so let's say we get through this and one side or the other is not happy, right? So then you enter what's called the appellate process. Any defendant has the opportunity to appeal a verdict to a higher level of courts. So if a defendant is dissatisfied with the verdict, they can appeal. Appeals are also possible in virtually every civil suit. For an appeal, it's a little bit different. The appellate judges will actually read things over. So they'll read the record, so the transcript of the trial proceedings. They'll read the pleadings, the motions, and accompanying documents filed by attorneys. And they'll read the briefs, written arguments from both sides about the issues on appeal. And sometimes briefs are written by other organizations. Like, for example, the APA has written briefs in quite a few cases, most notably Brown versus the Board of Education, arguing in that case that separate did not mean equal, based largely on the work of Mimi Phipps Clark and Kenneth Clark. Actually, Mimi Phipps Clark is right here on my Women in Psychology bag as one of the people who's represented. So then, after reading through all that stuff, the appellate judges will then decide whether to overturn the original trial decisions or to let it stand. Appellate judges rarely reverse a verdict on the basis of the facts of the case or the apparent legitimacy of the verdict. When they do reverse, it's usually because they believe the trial judge made a procedural error, allowing controversial evidence to be presented, for example. If a verdict is in a criminal trial and it's overturned or reversed, the appeals court will either order a retrial or order the charges just thrown out. If it's in a civil case, an appellate court can let the decision stand, or they can reverse it. So they would then rule in favor of the side that lost, or make some changes in the decision and remand, or return the case to a lower court for reconsideration. So one of the the things that we talk about, and certainly has come up a lot more quickly than it normally would, right, is the courtroom of the future, right? So during the pandemic, some of this stuff had to happen. So video conferencing, you know, that permits live two-way video and audio communication has been used this year. I don't know how much it will be used in the future, right? But certainly we've shown that it can be used for these processes. And so there've been a couple different viral videos related to this, right? One was the guy with the cat filter. Another was a really scary case where it was a domestic violence case, and the accused, the person who was the accused abuser, was in the same house with the victim, just in a different room during the trial. And luckily, her attorney figured it out because she realized the woman kept kind of looking to the side before she answered. And they sent the police out there because he wasn't supposed to, there was a restraint or like a no contact order. But that's terrifying, right? Because clearly there could be a misuse of things and justice not being served in those scenarios. Now more and more we look at electronic and digital evidence, so things like cell phone records and, you know, IP addresses, where people were when, things along those lines. Now as well, they tend to use computer animations and simulations. Let's say you're doing a civil suit around a car accident, right? You probably would have an animator put together a simulation, little short video clip that shows how the accident played out. Virtual environment technologies also allow observers to experience a recreation of an event as if they were actually present when it happened. So there's some question as to whether, you know, VR will become a bigger part of this in the future. I think some of these things are gonna, you know, stay around. Certainly we'd already had incidences where victims could be in the other room on closed circuit TV so they didn't have to face their abusers, for example, or in cases where kids were the witnesses, a screen placed in front of them, and sometimes they'll have therapy dogs in court, which I kind of love, to support the kiddos. So we're coming up with different ways to do things, but it'll be really interesting to see what the lasting effects of COVID are on you know, the process of the courtroom in the future. Alrighty, so we will stop there for today. And let me stop share so you can see y'all's lovely names. These aren't really your faces. And, you know, please be in touch if you do have any questions about anything that's coming up. And on Thursday, we will talk about non-traditional prosecution. Some of this we've talked about a little bit at the start of the semester, but you know, some of it will be new information. So I'll stick around for a couple of minutes in case anyone has questions, and enjoy the rest of your day.